Hi everyone, and welcome to SA Mining Desk, your partner in navigating the South African mining sector. In today's episode, we are comparing, side by side, the four main applications we have already discussed. The aim is to help you decide which type of application is most suitable for you from a business perspective, and to equip you with information from a community perspective so that you are better informed during engagement in the consultation process. First, it is important to point out that in South Africa, you may only mine or prospect for minerals if you have been issued with one of the following: a mining right, a prospecting right, a mining permit, or a reconnaissance permission, together with the required environmental authorization, except in the case of reconnaissance permission. These licenses and permissions are issued by the Department of Mineral and Petroleum Resources, DMPR, under two pieces of legislation: the Mineral and Petroleum Resources Development Act, MPRDA, and the National Environmental Management Act, NEMA. Mining without these approvals is illegal and may result in serious repercussions. Secondly, please note that you do not need to own the land in order to lodge these applications. You are also not required to consult with or obtain the consent of the landowner or lawful occupier before lodging application. In South Africa, mineral resources belong to all South Africans, and the government holds them in custody on behalf of the citizens. Let us begin with the topic of the day: purpose of each application. Each of these applications exists for a different purpose. Mining right, MR. This authorizes large-scale mining of mineral resources for economic gain. It also requires contribution to the socio-economic development of surrounding communities and promotes empowerment through ownership. Prospecting right, PR. This allows for invasive or non-invasive geological studies to determine whether a mineral exists in an area, its quality and quantity, and whether it would be economically viable to mine it, and using which methods. Mining permit, MP. This is intended for small-scale mining operations. Reconnaissance permission, RP. This allows for non-invasive geological studies to determine whether a mineral exists in an area. Lodging of the application. All applications are lodged through SAMRAD, which is the department's online application system. Please note, however, that the department is in the process of developing and launching a new application system, which is intended to be more effective than SAMRAD. This process is still underway. Application fees. Application fees are largely influenced by the environmental authorization (EA) process your application will follow. The exception is a reconnaissance permission, which does not require the EA and costs 100 rands. Generally, the application fees are as follows: mining permit, 2,100 rands, MPRDA 100 rand, and NEMA 2,000 rand. Prospecting right, 2,500 rands, MPRDA 500 rand, and NEMA 2,000 rand. Mining right, 11,000 rands, MPRDA 1,000 rand, and NEMA 10,000 rand. You are required to pay both the MPRDA and NEMA fees together as a single amount when lodging the application. In addition to this, you must consider consultant fees. These fees are not regulated and vary depending on the consulting firm you appoint. The consulting fee is paid to the Environmental Assessment Practitioner, EAP, who prepares the environmental reports on your behalf. This often makes the overall cost of applying for and acquiring rights and permits significantly higher. If you are a small-scale miner applying for a mining permit, you are encouraged to contact the small-scale mining unit within the DMPR. They may provide non-monetary assistance with preparing and lodging the application, which can reduce costs. Duration of the application process. For mining permits and prospecting rights, the process generally takes approximately 8 to 9 months, provided there are no appeals or objections. Mining rights take the longest and may take up to 14 to 15 months, again assuming there are no appeals or objections. Reconnaissance permission takes about 3 to 6 months. Extent of the area applied for. There are no restrictions on the total area extent you may apply for under prospecting rights, mining rights, or reconnaissance permissions. However, a mining permit is limited to a maximum area of 5 hectares. Environmental authorization requirements. Applications from mining right, prospecting right, and mining permit are lodged simultaneously with an application for environmental authorization. Generally, prospecting rights and mining permits follow the Basic Assessment Report (BAR) process. Mining rights follow the Scoping and Environmental Impact Assessment (EIA) process. These reports are prepared by an environmental assessment practitioner who must be registered with EAPASA and is appointed at your own cost. A reconnaissance permission does not require an environmental authorization. Queuing system. The MPRDA applies a queuing system, meaning applications received on different dates are dealt with in order of receipt. Applications received on the same date are regarded as competing applications, and preference is given to historically disadvantaged persons. The department will inform you if your application is affected. For prospecting rights and mining rights, once an application for a specific mineral and land has been accepted, other applications for the same mineral and land are blocked until the first application is either granted or refused. If the first application is refused, the land becomes available again. If it is granted, the blocking continues for the specific mineral granted. Mining permits operate slightly differently. A second application may be held in abeyance until the first application is finalized. If the first is issued, the second is rejected. If the first is refused, the second application becomes first in line and is processed further. Consultation. Consultation is not required for a reconnaissance permission. However, for all other applications, the applicant must consult with interested and affected parties, I&AP, including landowners, lawful occupiers, and certain government institutions after the application has been accepted. The outcomes of the consultation process form part of the environmental reports, such as the BAR, that are submitted to the department. Objections and comments. For all applications, except reconnaissance permissions, the department publishes a notice after accepting an application. These notices are displayed at municipal offices, libraries, schools, and other public places. The notice invites public comments for a period of 30 days. Members of the public may submit comments or lodge objections. Objections are referred to the Regional Mining Development and Environmental Committee, which considers the issues and advises the minister. Both the applicant and the objector may be invited to present their cases. Matters considered by the committee often include conflicting land uses, such as farming and mining. This mechanism is important to ensure community participation. Communities are encouraged to monitor these notices, submit comments, and lodge objections where necessary. Decision on granting. Only mining rights and prospecting rights go through a formal granting process. However, when it comes to environmental authorizations, all applications except reconnaissance permissions are granted or refused. The decision to grant an environmental authorization is consulted with interested and affected parties who are afforded an opportunity to appeal. However, the decision to grant a mining right or prospecting right is not consulted with interested and affected parties. This often creates challenges, as affected parties may only become aware of the decision after the right has been issued and the holder issues notices to landowners or lawful occupiers, at which point they may appeal the decision, whilst they may have done so when the application was still granted. For this reason, it is advisable to inform all interested and affected parties once you receive a granting letter. Notarial execution. Reconnaissance permissions and mining permits do not require notarial execution, and the holders do not enter into a contractual agreement with the department. The terms and conditions are listed in legislation. Mining rights and prospecting rights are executed before a public notary. The holder enters into a contractual agreement with the department, which sets out the terms and conditions of the right and incorporates supporting documents such as the social and labor plan and the mine or prospecting work program. Although this is a contract, the terms and conditions are prescribed by legislation. Note that the cost of retaining a notary public is borne by the applicant. Registration and recording. The Mining and Petroleum Titles Registration Office is responsible for registering or recording rights and permits. Mining rights and prospecting rights are registered and acquire limited real rights status. Mining permits are recorded. The office affixes a stamp and allocates a unique number as proof of registration or recording. This process is regulated by the Mining Titles Act and attracts prescribed fees. Duration of rights and permissions. Reconnaissance permission, issued for a maximum of 1 year and is not renewable. Prospecting right, issued for up to 5 years and renewable once for up to 3 years. Mining permit is issued for up to 2 years and renewable 3 times for 1 year each. Mining right is issued for up to 30 years and is renewable. Please note that renewals do not require consultation, and interested and affected parties are therefore not consulted during renewal processes. Appeals. If an applicant or interested and affected party is dissatisfied with a decision made under the MPRDA, whether acceptance, rejection, refusal, or granting, an internal appeal may be lodged. Appeals must be submitted within 30 days of becoming aware of the decision. Lodging an appeal does not automatically suspend the decision. A request for suspension must be included in the appeal. The appeal fee is 500 Rand. Appeals must be lodged with both the regional office and the Chief Director Legal Services at the Pretoria office. Transferability. Transferability refers to the sale of a right or an interest in a right, such as shares, to another entity. Under the MPRDA, ministerial consent is required for such transactions to be valid. This process does not require consultation with interested and affected parties. Only mining rights and prospecting rights are transferable. Mining permits and reconnaissance permissions are not. Empowerment requirements. Only mining rights carry an obligation to meet empowerment requirements prior to granting. Social and labor plan. A social and labor plan sets out how the holder of a mining right will contribute to the socio-economic development of mine communities, for example, through community development projects and bursaries, to name some. This plan is reviewed every 5 years for the duration of the mining right. It is not required for prospecting rights, mining permits, or reconnaissance permissions. Payable fees. Mining permits, prospecting rights, and mining rights are subject to state royalties administered by SARS. Prospecting rights holders must also pay annual prospecting fees in advance. These fees are calculated based on the total area, starting at 1 Rand per hectare and increasing annually. Mining permits, prospecting rights, and mining rights must pay financial provision, which is reviewed annually until a closure certificate is issued. This amount is refundable upon the issuing of a closure certificate. Cost overview. When applying for these rights, you should consider the following cost components: application fees, consultant fees, notarial fees, registration or recording fees. This brings us to the end of today's episode. In our overview of the 4 main application processes under the MPRDA. We hope this comparison helps you determine which application is most suitable for you and better equips interested and affected parties during the consultation process. If you have any questions about these applications, please submit them via the WhatsApp link provided below. Your identity will remain anonymous, and the question will be answered on the platform for the benefit of others. You are also welcome to submit hypothetical scenarios. Thank you for following us and for your continued likes and comments. We truly appreciate your support. Until next time.